Okay, so good night. Second great lectures and presentation. This is about patent law, and as always, we take a comparative approach between US, China, and the European Union. So let's go further with it. So, introductory part. This is about what is actually a patent. So, a patent is actually an exclusive right that inhibits others from utilizing the patent invention, importing it, and basically have the economic gains from such invention. Okay, patents are normally referred as monopolies in economic literature, but legally talking, we are not in phase of a real monopoly actually, but it's much more an indirect monopoly, as you don't have the right to do anything. You don't have the monopoly on the production of it or whatever. You just have the monopoly on the invention itself, of the idea itself, and therefore is much more offensive towards other economic right than an active monopoly. So there are, on the theoretical framework of patent, there are two main areas, as we've seen, as the same are actually on the previous lecture of copyright law. So we actually have the utilitaristic one and the natural rights humanistic view. So while the utilitaristic one is the one based on the Arrow's information paradox, the Arrow's information paradox starts from the way that any kind of information and idea is not as a material good, basically as a physical good. Why is that? Because although you can give it value, basically, once you have shared it, basically its possession still stays on top of the two persons. Hence, basically, here's the main problem of sharing ideas. Basically, you are not, without patents, you are not incentivized to actually sharing ideas in order, for example, to seek out for investments, as your returns on it could be highly put into jeopardy. Why? Because you already told the person what is your idea. Maybe you have already given the documentation on even the idea itself, and now to build it up, and then you find yourself basically giving already to another person your idea. This principle, the principle of having an incentive that is given through patents to inventors and to their disclosure, is actually mentioned in US law in John Deere versus Graham. It is a case from 1966, and we're going to talk about it actually later in the presentation. The other great area is actually the one of natural rights, the humanistic view that stems from actually the European law perspective. For example, the French Patent Statute of 1791, which considers patent invention as a extension of the human ingenuity and the human right to create, basically. And hence there is a deep connection between human personality and the invention itself. So let's go forward. Now, history of the patent system. We have the first example of patent system in 1474, especially in Venice, in which there was actually a kind of rights given to inventors of novel and effective device. That's why Venice was one of the epicenter of innovation during the humanistic period, when the 14th and 15th century, in Italy at least. Then in the UK there had been the evolution, we could say, of patent law, as there was for the first time the idea of a monopoly connected to patent itself. At that time, Queen Elizabeth I will issue a series of letters of monopolies, basically granting monopolies, and such letters basically will be considered later as odious monopolies, because would give a lifetime right over the invention on its production and so on. You see how much copyright in this phase and patent law would collapse within itself. The Statute of Monopolies in 1623 was actually the first shaping of patent law in the sense that we have right now. So not an eternal monopoly, but one limited in time. At that time was 14 years. Today is much more, 20 years, basically everywhere. And was issued retracting the monopolies that were first issued by Queen Elizabeth I. In the US, until 1836, the patent system had many trial and error, and it was basically operative already in the mid of 19th century, while in the EU after 1883 and hence the Paris Convention, we had to wait almost 1 century before the European Patent Convention was established, starting to create the unified idea of a unified patent system. So the first thing to take into consideration when we talk about patents is the condition of patentability. So what is patentable? And basically in almost all jurisdictions we would have defined subject matter, so what is patentable, and going deeper is that subject matter encounter the requirements of usefulness, novelty, and inventive step or non-obviousness, depending on where you are. Talking about subject matter, this one is mentioned in Article 27 of the TRIPS agreement, which mention that patent shall be available for any invention, would it be a product or a processes, in all fields of technology, provided that they are new, they have an inventive step, and they are capable of industrial application. So we see these threefold requirements for subject matter, that is a novelty, new, involve an inventive step, inventiveness, and utility, capable of industrial application, so to be useful in practice. Patents shall be available and enjoyable without discrimination as to the place of invention and the field of technology, and whether products are imported or locally produced. So what this means is basically that if I invent something but I'm based in China, I can actually patent it in US. I don't need to be a citizen. This one was a great talk when there was for example, this one is quite different, for example, from copyright law. Copyright law doesn't work like that, for example. Members may exclude patentability from patentability some invention, the prevention within the territory of the commercial exploitation shall be based on grounds of protect public order or morality, protect humans, animal or plant, life or health, or to avoid self-prejudice to the environment, provided that this exclusion is not just taken into consideration in the law. What does it mean? That there could be exclusion under Article 27 TRIPS that are done by the member states, but these are just on the public interest grounds, so grounds of protecting the public interest, the human and personality interest, as well as the animal and plants interest. We're gonna see why this is a slippery slope, because many times, especially in biotechnology, we have bacteria that are patented, right? Or we had, for example, Ray Edinburgh, I suppose it was in 2009, if I don't mistake, that was an application for a cloned, for the first cloned sheep, if you remember the Dolly, the sheep Dolly in Edinburgh, and it was they tried to patent it in the US, but it didn't fly. Another important interest is 27.3, in which is stated that member state of TRIPS may exclude the diagnostic, therapeutic, surgical methods and treatment for humans and animals, as well as plants and animals, other microorganisms, and essentially biological processes for the production of plants or animals or other than non-biological macrobiological processes. Okay? This one, as I say, is a pretty trusted clause because in microbiology, for example, in biotech, in nanotechnology, many times what is patented is actually a living creature, a living being, a bacteria, or an enzyme, or stuff like that, basically, or a reproduction of it. So many times the question of what is patentable and what is not becomes very relevant for the contemporary landscape of technology, especially in the biotech industry, or right now even for quantum technology, for example. Then, of course, there is this one is a possibility. It's written that may also exclude from patentability. This means that the exclusion from patentability is basically decided in accordance to TRIPS, but TRIPS could be basically avoided. This means that member state could decide to actually patent them. And we actually have seen them, for example, in the US, and we're gonna see the case later on in the presentation, but these are already happening. Just for saying that there have been this decision that were taken in 1994, I suppose was the TRIPS, but still the ongoing development of technology have actually challenged what were the statements that were made by the member state and the agreements that were being made in TRIPS. So going on, let's go to the US law. US law under 35 USC section 101 describe what is patentable. And what is patentable is described as whoever invents or discovers any new and useful, so novelty and usefulness, process, machine, manufacture, or composition of matter, or a new and useful improvement thereof may obtain a patent, therefore, subject to the condition requirements of this title. So what does it mean? That on a side, you have four main categories: process, machine, manufacture, and composition of matter. These four, under US law, are the great main categories on which your invention shall enter into. Right? So when you invent something, it shall be a process, it shall be a machine, a manufacture, or a composition of matter. If you're outside of these four categories, basically you cannot have your invention patented. Then a second set of actually requirements is the novelty and the usefulness. We have seen that there is even a non-obviousness requirement that is decided by US law, and we're going to see later in the presentation. But for now, what is important is that you need to have a process, a machine, a manufacturer, or a composition of matter that is new and that is useful to the tech field you take into consideration. Now, let's see. Now, there are a series of exclusions that have been found by the case law regarding to patent, basically. There are two main broad areas. One is laws of nature and natural phenomena. The other is abstract ideas. Now, laws of nature and natural phenomena means something that, from a side, the laws of nature is something are universally applicable truths that decide the behavior of the natural world, while the natural phenomena are things that occur in nature without a human intervention. Now, this human intervention is pivotal in US law. We're gonna see that from the get-go. So from the Latimer case, that is one of the first case that is face the problem of what is patentable and what it isn't, actually faces the problem of natural phenomena and laws of nature against the human agency. So natural phenomena are always things that occur in nature without human intervention. So while laws of nature are something much more, we could say, abstract, so they are not a material thing, maybe, for example, the law of thermodynamics or something like that. Natural phenomena are the physical occurring thing, for example, a leaf, the wind, whatever. You see what I mean? While abstract ideas are concepts that are fundamental or basic and that lack the requirements of usefulness. So what does it mean? That they are so abstract that actually their applicability in any kind of technological industry or any kind of technological field is not possible. So let's go on with our presentation. So important cases, as we say, ex parte Latimer is from 8089. This one is one of the grounding case, one of the beginning of the case, which draws the line between invention and discovery. And he marks the fact that for having an invention recognized as such, you will need a human intervention, a human agency in order to have it done. If you remember, this thing is interesting because this stressing of human agency is even the same argument that is utilized, that have been utilized in US and the European Union in regards to copyright related to artificial intelligence. So artificial intelligence could not be copyrightable because there is not a human agency behind it. And this had been happening even other times, for example, when there was animal copyright and so on. But here it's very important actually, because in patent law, consider that patents are actually the kings of the IP rights that you can achieve. They cost much more than copyright, they cost much more than trademark, and they are way more strong in being defended, basically. So being so important, the requirement of human agency becomes fundamental, if not pivotal, in having your patent application recognized as actually granted. Let's go with the other case. So we have Park Davis and Company versus H.K. Mulford Company in 1911, in which the court deemed an invention patentable even if it was a purified form of a glandular substance, because it found that even if this is a substance that you can encounter in nature, actually showed a human intervention in it, because it was purified, there was a process on it, and hence, as long as there was a human intervention, it's no more a discovery, but it becomes an invention. We see then in 1948 Funk Bros Seed versus Calo Inoculate Company, in which the court had that the mere discovery of a new phenomenon in nature cannot be patented. And then the important case for, especially for the biotech industry, that is Diamond versus Chakrabarti in 1980, in which the court, for the first time, against what would be the TRIP agreement, basically, would say that the court that a bacteria, a living being, was patentable as it was genetically modified by a human agent. Okay, so as there was a human intervention in the bacteria itself, hence it was patentable. So this is you see how much groundbreaking this is, basically, right? Because this means how much patent law need to reshape itself in face of the new technologies, because until 1980 it was impossible to genetically modify a living being, okay? And in that case, in that particular case, a living being was modified, a thing that used to live in nature, right? So that normally, that at the time of Latimer would be considered as the Latimer case. So force of nature, a natural phenomena that could not be patented. Instead, in this case, it was highlighted how much the human intervention means that it could be patented, right? So it is interesting because for me it opens a great question. If I create a new breed of dogs, would it be patentable or wouldn't be? Probably not. But in any case, next case is Ren Nguyen of 2007, in which the court held that a signal was not patentable, as we said before, because it doesn't enter inside the category highlighted in section 101. So that's why the categories that I mentioned to you before, that were, if you remember, machine, manufacture, processes, and mixture of matters, these four main categories are super important, because in Ren Nguyen was underlined that the signal altogether was novel, altogether it has human agency, altogether was usefulness, altogether it has all the other requirements, doesn't fit into one of the four categories. Hence, as it doesn't fit into the four categories that laws have foreseen back in the days, you can patent it. So you see how much, as an inventor, you find yourself tighted. So let's go with the last cases. These are very important actually. So you will have Mayo Collaborative Services versus Prometeo Laboratories Inc., in which the court evaluated the patent eligibility of a diagnostic method, and the court claimed that the claims were too connected with a law of nature, and that is not sufficient to simply state the law of nature and then the words apply it. Okay, so what does this mean? That in Mayo Collaborative and Prometheus Laboratories Inc. case, they actually created a method based on the utilization of a law of nature. So if there was an utilization of the law of nature, for the court wasn't enough. There wasn't enough human agency in order to apply such methodology. So if there wasn't enough human agency, there could not be patentability. Then we have seen that even in TRIPS, actually, diagnostic methods could be banned from actually be patentable by a member state. This depends where you are and whenever you are, basically. Now, other case, Association for Molecular Pathology versus Myriad Genetics. The Myriad case is super important because the court here decided that genes that were implanted without all the natural structure and function were patentable. So you've seen here that this is super interesting because if you see how much it changes from the case of Chakrabarty back in 1980 from Myriad in 2013. In 2001, in Chakrabarty, there was an active intervention of the human being in modifying the gene of a bacteria. Here instead, in the Myriad Genetics case, we don't have such an active intervention. We just have taking a gene and implanting it in a sense that is no longer connected with its natural environment, but is connected in basically in a totally new way. So this one is considered novel. It's considered useful. Of course, it's considered even having even the non-business requirement. But on the other side, what was interesting was that it was considered as being patentable, as it had a lot of human agency in it. But we see the human agency in here becomes shorter than actually the one that was in Chakrabarty. So this one is pretty interesting, right? Because you find yourself seeing that human agency here is restrained between just changing the meaning of the gene, while before there was an active interest in actually changing genetically the gene in order to make an organism do something else, a particular task. Now a super important case is Alice Corp. Now this one was my favorite case because once in 2014 this was approved, basically created chaos inside the mind of all the inventors of the software developer and so on. And we're gonna see why. Basically, in Alice Corp versus CLS Bank International in 2014, the Supreme Court held unanimously. So this means everybody was agreeing on this, that the claims were drawn on an abstract idea, and hence they were not patentable. Okay, Alice Corp had the idea of abstract idea connected to a software. So that's what is scary, you know, because when you're a software developer, you start to understand that you're not, from 2014, people start to not be so sure that actually their patent will be granted, that their invention will be recognized as an invention, although there was novelty, although there was usefulness, although there was non-obviousness, although there was human agency. Still, maybe there was an abstract idea. Their invention could be considered as an abstract idea. And there was even a two-step test that Alice Corp created. The phase one is determining whether the claims are directed to a patent non-eligible concept, so an abstract idea. While phase two is to search for an inventive concept that ensure that the patent is more than just the phase one finding. Now, this one is where the problem starts, okay? Because the definition of what is an inventive concept, I'm gonna see it later in the presentation, is something very blurry, okay? And many times it's related to the non-obviousness even considerations and inventive steps that comes from someone that is skilled in the art, okay? When you talk about some fields of technology, especially the new fields like AI, like quantum technology, especially, for example, or the one that I love, for example, quantum machine learning, quantum AI, you have a person that is skilled in the art that is way difficult to find because you actually have someone that have to be skilled maybe in AI, have to be skilled in quantum, so in physics, in a concept particular, not very, familiar maybe for a tech developer. On the other side, if you wanna use the usefulness concept in order to have your patent approved, you find yourself with a third layer of difficulty because you have a quantum AI technology maybe applied to biotech, so to the biotech field or to medicine. So you will need someone that is an expert in medicine, of AI, and finally of even physics and so on. Of all these three things, you see that we're talking about something very peculiar, and so it's way more difficult to decide what is obvious and what is not obvious, what is an inventive step and what is not. This one is very difficult because in that case, you will find yourself basically to jeopardize your own patent. And you know that when you jeopardize your own patent, you jeopardize an investment that came not only from you, but even from investment funds and so on. So you see how much all a tech field here is put in jeopardy, is put in dire straits because of a decision of the Supreme Court. Now let's go to the EU. So Article 52 EPC, super important in this one, describe how the European patent shall be granted for any invention in our field of technology, provided that they are new, involving inventive steps, and are susceptible of industrial application. You see how much this one is in line of the 27.1 of the TRIPS, right? It's not talking about usefulness as, for example, the US law, but it's talking about industrial application as the TRIPS. So what is interesting is that Article 52 in the EPC doesn't have categories as there are in the US, no? The forming categories of machine, of procedure, mixture, and so on. But it has just the requirements. So novelty, the new feature, the industrial application, the usefulness requirement, and the inventive step that in the US is considered as the non-obviousness requirement. Now let's see. So there are series of exclusions that in this case are not just indicated in the case law, but even in the APC 52 second paragraph that underlines that discoveries, scientific methods, and mathematical methods, aesthetic creations, schemes, rules, and methods, and computer programs, as well as presentation of information could not be patentable. You see how much crazy this is in a way, right? Because you have computer programs that are not patentable, mathematical methods that are not patentable. If you're talking, for example, about quantum technology, there is even the patent claims are basically mathematical explained and mathematical methods, right? And especially when you're talking about AI, scientific theories and mathematical methods are described into the patent, as well as computer programs. So you have a blend of two things that normally wouldn't be actually recognized as patentable. You know, in the 90s and the 80s, someone would laugh about the idea of patentability as the great main issue of 21st century patent law. But that's the thing. In the 21st century, the great issue is no more inventive step or the usefulness or so on. The great issue is the basis, literally the basic of it. So having your idea as your invention as a patentable matter, changing and blending it in order to make it fit into the patentable matter of the laws of US, of EU, or China that we're gonna see later. Let's see the notable case. So one of the first important cases is 208/84 in 1986. This is the Vicom case that underlines, you see how much in the 80s there was a first change, now, right? In US we have Chakrabarty, which changed the idea of what is patentable in relation to the laws of nature, and basically in relation to organism that could be patentable, while the Vicom case in Europe is related to mathematical methods. Okay, so to more abstract idea. So abstract idea, mathematical methods will not be patentable unless they have a technical character. So you see how much this shift. So, okay, we hear you. You can have your invention based on mathematical methods, for example, as quantum law, but I want at least a technical character. What does it mean? Technical character in the UIPO approach right now means to have a problem solution approach. What does it mean? That basically you will have a problem in the tech field that is solved through the practical application of your abstract idea. Okay. Now this is debated. Why? Because the IPO guidelines is still written that this will be debated on a case by case. This is not sure you're gonna get your patent. You have your patent granted on your idea. For example, if you have quantum softwares, okay, you will not be sure that they're gonna be patentable. Why? Because if the WIPO finds that the technical character is lacking, and we're gonna see later how they're gonna evaluate it based on the problem solution approach, then you want to have a patent. But you see how much it is, it goes against the idea itself of patent, because patents are there for protecting innovation, basically. But on the other side, right now, they are hindering it in some particular tech fields that are actually the tech fields of the future. So this is very interesting for me. Anyway, going on. T931/95 pension benefit case. This case, again, faces on methods, on abstract methods, and the notion that there needs to be a technical character to be patentable, and it must solve, as we say, a technical problem. T1227/05 Infineon Tech case. Instead, the decision underlines here that no feature can be described in terms of technical means necessitating for having a technical character. An invention that uses a mathematical method can still be technical if it serves a technical purpose, as we said before. So you see that the problem solution approach basically had been reinterpreted 3 times in the UIPO history. So in Vicom case, pension benefit case, and Infineon Tech case. So there must be a technical character, and this technical character must fit a technical purpose, a solution for a technical problem. Okay, but as I told you, this is a very broad meaning, right? So you're sure you're gonna find problems on it, basically in the long run. Another important case is the Convict case of 2010 that tackles the idea of the invention and the system combine both technical and non-technical features, and the board recognizes that the claim might have both technical and non-technical features, and the presence of non-technical features that would not automatically negate the technical character, introducing the idea of an inventive step assessment using a problem solution approach considering the technical features. This one is the idea of the inventive step assessment that was introduced in 2010, and that was introduced by the Convict case, and the claiming that technical and non-technical could actually blend together as long as there is an inventive step, so something inventive that actually could solve an issue in the technical field. Okay, so now let's pass to my favorite, China. So at Article 22, paragraph 1 of the Chinese patent law, you would have that any invention or utility model, because in China they have even utility model that is something different, is a blended, is a way simpler way of having a patent, which a patent right may be granted, must possess characteristics of novelty, inventiveness, and usefulness. So in this article we've seen that is a step back even from the EU way. So there is no more the relation to
the relation to a technical field, right? So in US you see there is a technical field that you should apply, and there shall be a machine, a process, a mixture or something else. Okay, in the EU they say okay, you could skip the 4 categories, but still you should have any kind of invention related to a technical field that has this requirement: novelty, inventiveness, inventive step, and industrial applicability. In China there is no more, it doesn't exist the mention to a technical field. So is any type of invention, anything you would like to patent, basically, that has novelty, inventiveness, and usefulness. So you see how much in China there is a different approach, right? Because they said to you, you can patent everything, but of course there are the limits that they recognize as, even in China, they recognize the limit of natural phenomena and so on. But you see how much they start from the idea on a more open interpretation of what could be patented. Oh, let's go. Now, Article 25 of CPL actually talks to us about what is not granted as a patent, what doesn't qualify as a patentable subject matter. That will be discovery and scientific method, abstract idea, methods for diagnosis, and the presentation of information. So you see that they follow a lot trips, right? So the same way as European Union, they recognize that methods for diagnosis will not be recognized as grantable a patent. And of course then they have the abstract ideas, the discovery and scientific method, and the presentation of information, okay? In the same way as the European Union and the US in this case, okay? Now let's see. I'll see my beautiful infographics. So now condition of patentability, okay? So if you remember, we talked about the fact of what is subject to patent, right? And that in the EU and in China, but even in US, is mentioned 3 main requirements basically. In US too, that are novelty and usefulness, but there is even non-obviousness, it's just that it's not quoted in 101, in section 101, while in the EU is always quoted, as well as in China, in EU in the 52, Article 52, and in China in Article 22, is quoted that there must be novelty, of course, usefulness or industrial applicability, and even non-obviousness or inventive step, okay? Or inventiveness is called in Chinese. So let's go to see this principle, okay? I think I will take just a little break, just 1 minute, actually to take a sip of water. Okay, so I'll return to our presentation. Let me open it again. So as we say now, we are going to deep dive into the various requirements. So novelty, utility, inventive stuff, or industrial applicability, as we would like to talk about. So we start from actually this later one. So the utility principle or the industrial applicability. So we have seen that Article 27, first paragraph actually, quote the industrial applicability principle as established alongside novelty and the inventive stuff, non-obviousness. But all these 3 are not actually defined in the agreement, but leave the possibility for the member state to interpret these requirements in their own national legislation. So we're gonna see the first one, US. So the US utility requirement is defined actually in section 101, in which is established, as we've seen before, that the claims must be novel and useful. This means when they're useful, that they shall be scientifically plausible and then led to a specific and substantive use of the invention. The answer here will be as the inventor identified a use for the invention itself. Important case here, for example, Ray Fisher in 2005, in which the case the Federal Circuit found that utility needs to be specific to be specific, substantial, and credible. Now you see the train starting. I got too much fun in creating this this thing. So now the treaty requirement is that in the EU is defined by Article 57 of the EPC that describe industrial applicability. An invention, as we have seen, is even described in Article 52, is mentioned in 52, but is described as deeply in Article 57. So it is described that an invention shall be considered as susceptible of industrial application if it can be made or used in any kind of industry, including agriculture. This one is rather a broad standard for what qualifies as industrial applicable. So if an invention could be used in any sector of the industry, it actually fulfills the criterion. Okay. Now let's see the flying boat. You see, I enjoy too much creating this kind of thing. So the treaty requirement in China instead is defined by Article 22, paragraph 4. In Article 22, it is interested because they have a different approach from the EU. While the EU have Article 52, and then, for example, you've seen Article 56 and so on, that we're going to describe separately what are the requirements. In Article 22 in China of CPL, everything is described. They say to you novelty, inventiveness, and usefulness, and they basically describe it in the same paragraph and in the same article. So in Article 22, paragraph 4, you know that usefulness means that the invention or the utility model can be made or used and can produce positive results. This article is interesting because it's linked to positive results, right? Meaning that the first thing to take into consideration is not only the utility for a particular tech industry, but the fact that could have a positive result, meaning that could have an actual solution for a problem. You see the problem solution approach that is even mentioned in Article 22, paragraph 4. Now let's see instead the novelty requirements. This one is very important. As you've seen, is mentioned in everywhere. So this one is mentioned in 101, we've seen 35 section 101, but it's even mentioned in 102 letter A, in which is written that a person shall be entitled to a patent unless the claimed invention was patented and described in a printed publication or in public use on sale or otherwise available in the public before the effective filing date of the claimed invention, or the claimed invention was described in a patent insert and in section 151 or in an application for a patent published or deemed published under section 122 letter B, in which the patent or application, as the case may be, names another inventor and was effectively filed before the effective filing date of the claimed invention. This one is the mention of the novelty test, is the claimant identically described. Identically described where? In previous patent application, okay, or in any printed publication, in any public use, in any sale, or in any information available to the public. So you see that this is mentioning a lot of things, not only patents, not only is mentioning patents, but even what is called the prior art. So whatever is coming from public documents, presentation, sales that are happening between parties, public sales, or any kind of public disclosure that could happen. Section 102, it is interesting because have been changed with the American Invents Act in 2011. Okay, so currently there are actually two systems operating in the US. One is pre and one is post March 16, 2013. Okay, the pre-American Invents Act was a first to invent principle, while the post-American Invents Act has a first to file principle. What does it mean? That previous than the American Invents Act, so from the Patent Act of 1952, actually patent law prescribed that whoever invents first has the right, the monopoly, has the patent, okay? even if it didn't file the patent. So if I created the invention and it was publicly known that the invention was created by me, even if I didn't file the patent, then I have the right to it. And the patent of the other person, or better, that nobody else could have that patent. Okay. While instead, in the post-American Invents Act, the thing has become much more related to a first to file. This means that it doesn't matter who had first invented it. What it matters is who had first filed the application. So if I filed the application and another person have invented it in the other side of the country, okay, and didn't file an application, then I have the right of it. And better if me and him both file an application, me on June and the other person is gonna file it in August, I'm gonna be the one that has the patent. Why? Because I was the first to file. While instead, pre-American Invents Act, there would be an assessment of who had invented the whole thing first. Okay. Now, the main changes that happen are actually in the section 1 or 2, are in the section 1 or 2 letter B. Why? Because this one are the sections that are describing from a side the grace period, and from the other the one of the public sale or public disclosure. We're going to see them. So the exception on the 102 letter A in the new section 102 letter B are that disclosure made 1 year or less before the effective filing date of the claimed invention. So a disclosure made 1 year or less before the effective filing date of the claimed invention shall not be considered as prior art to the claimed invention under this subsection. If the disclosure was made by the inventor or joint inventor or by any other who obtained the subject matter disclosure directly or indirectly from the inventor or joint inventor, or if the subject matter disclosure had before such disclosure been publicly disclosed by the inventor or a joint inventor or any other who obtained the subject matter disclosure directly or indirectly from the inventor or a joint inventor. What does it mean? That any disclosure that happens publicly 1 year before the filing of the patent, if it has been done by the inventor, the joint inventor, or anyone that had been directly or indirectly authorized by the inventor, okay, it's not considered as a public disclosure, as a prior art, as a public disclosure, and doesn't represent a ban on the filing of the patent, okay? Even if the subject matter and not the patent was disclosed. So it doesn't matter if it was, it could be the patent itself. So I'm patenting this one is the patent, these are the claims, this is what I'm doing, and if you would like to invest in my patent, that's what we're gonna do, and that's what we're gonna achieve. So that's the interesting part. The same thing on the subject matter. So that is interesting because in section 102, exception are foreseen in letter B, and is described in 1A and 1B that it doesn't matter if it was the patent itself or the subject matter of the patent. In any case, whatever is going to be filed basically is going to be protected if it has 1 year before the filing date. Okay. Now, disclosure opinion application and patent disclosure shall not be prior to a claimed invention under subsection 2 if the subject matter disclosure was obtained from the inventor or joint inventor. The subject matter was disclosed, magenta disclosure had before such subject matter was effectively found in the subsection been publicly disclosed by the inventor or joint inventor or another who obtained the subject matter disclosure directly or indirectly from the inventor or the subject matter disclosure claimed invention no later than effective filing date claimed invention were owned by the same person subject matter to an obligation of assignment to the same person. Okay? So, what does it mean? The second part is another very important part because it describes that even the disclosure that instead appears in application and patent, okay,
shall not be considered as prior art, okay, if the subject matter was disclosed or obtained directly or indirectly from inventor or joint inventor, or the subject matter, as before, was effectively publicly disclosed by the inventor, or so on, okay, or so on, or the subject matter disclosed and the claim invention, okay, were owned by the same person, or subject to an assignment by the same person. What does it mean? That the last part is basically based on the idea that if I was subject to an obligation of an assignment, or I was owned by the same person that filed it, okay, and it was quoted in previous disclosure that appears in application of patents, this is not considered as prior art because it's the same person doing it, basically. While in the other case, is because the disclosure, as always, has been done by the same person. So you see 2 points. 1 point is the grace period of 1 year. So it's not considered prior art if you publicly disclose it, both being subject matter or the patent itself, to a public in 1 year before the filing date. The second part instead is, even if you actually mention your invention in other patents or in other applications, okay, totally different from the one you're presenting right now, it was considered as prior art if you were the same person doing the application. And the same thing if you owned directly or indirectly that patent, or there was any agreement underlying that other patent filed in which you came out on top. So that it is. Now, there are important differences in post-American Invents Acts, okay? So, the first one is the grace period, okay? So, the inventor discloses the subject matter, as we say, so disclosure will not consider against the invention is defining happens within 1 year after the disclosure. The disclosure by anyone else, if someone else publicly discloses the same subject matter after the invention's original public disclosure and before the inventor's filing date, that disclosure will not even considered as prior art. And derivation proceeding. The American Invents Act provides for derivation procedure, which assures that even a first-to-file system, a person who derived an invention from the original patentee cannot obtain a patent. Okay. Now, what is important is that before the American Invents Act of 2011, the prior art and the prior knowledge will be assessed. What does it mean? Will be investigated if the public disclosure happened in the US or abroad. Why? Because before the American Invents Act, this evolving grace period, the protection against derivative work from your own patent, derivative work from derivative proceedings that came from your own patent, or that your patent have taken inspiration of, that is owned by you, or public disclosure and so on, that is made by you, will need to be happening in the US. Outside the US, it didn't matter. They were considered as public, as prior art. So this is what occurs. It's not the grace period applied internally, but never externally. Okay. Now the American Invents Act changed this, of course, because they understand they were in front of a new globalized world, and basically you will search investor everywhere. So it doesn't mean to have this kind of exception, we could say. The important requirement here is that for knowledge and for public use to be considered as prior art, it must be enabling. So it must be able to give to the person that is listening to it and that is an expert on the field the possibility to recreate the invention and to utilize it. So this one came from Minnesota Mining case versus Chemke Inc.
So we're gonna see the important case here actually. So important case here as Geiler versus Wilder in 1815, in which for the first time it was mentioned that prior art outside the US was not relevant because in that time was 1850. The court said, you know, Americans couldn't know what is happening in Europe, couldn't know what is happening in China. They don't know. So who cares that we take into consideration? Of course, it was another century. So Egbert versus Lippmann in 1881 instead is an important case because it expanded the understanding of what constitutes a public use. Even if an invention indeed is not visible or apparent when used publicly, it's still considered as a public use. Okay. Then we will have Metallizing Engineering Company versus Canyon Bearing and Alto Parts in 1946, in which the court concluded that a secret commercial exploitation of the patented process for over a year before filing the patent application would constitute a public use. Okay. Then Rosaire versus Barrel Sales Divisions in 1955. The court decides that even if an invention is used in a location where the public does not typically go, it might still be considered as a public use. What is interesting in these two cases was the accessibility requirement. So, if you would have the possibility for the public to access to the utilization of the invention, then you would have a prior art. We're going to say this in these cases actually. So Rewider in 1973, because I highlighted the important role of public accessibility, as we were mentioning, right, for determining whether a document constitutes a printed publication. In Ray Hall in 1986, in the case, instead the court held that the accessibility is more important than the actual dissemination. So it's more important that potentially you could access it than actually that there was the dissemination of the content of the prior art to a wider public. In Ray Croydon, instead, in 1989, the court focused on what constituted a printed publication accessibility to the public. Then Lockwood versus American Airlines, very important this one, 1997, in which the primary focus was to establish if the use of a patent process in public constitutes a public use. And again, the accessibility criterion was used, and the one that was mentioned in Rewire and even before in the metallizing industry. Public use if the activity is not secreted or concealed. Then, in Re Klopfenstein in 2004, the decision explaining the limits of what can be considered as a printed publication, the court re-emphasizing the accessibility criterion. So we see that the accessibility criterion is reported many times in case law. Now let's go to see the European Union. The European Union novelty is defined by Article 54, 1 and 2 EPC, in which is stated that an invention shall be considered to be new if it does not form part of the state of the art. And secondly, that the state of the art shall be comprised everything made available to the public by means of written or oral description, by use or in any other way before the date of the filing of the European patent application. This one is the same, you know, in Article 54, paragraph 1 and 2 that we see in section 1 or 2 in US, right? Letter A. So that novelty is based on the public art that came before, that is any kind of making available to the public of the invention by use or in any way, written or oral, before the patent application. Article 55 focus on the exclusion. This one is very interesting because from the application of Article 54, a disclosure of the invention shall not be taken into consideration if occurred not earlier than 6 months preceding the filing of the European patent application, and if it was due to or in consequence of an evident abuse in relation to the applicant, if it was due to or in consequence of an evident abuse in relation to the applicant or his legal predecessor, or the fact that the applicant or his legal predecessor displays the invention at an official or officially recognized international exhibition, falling within the terms of the Convention of International Exhibition signed in Paris in 1928 and last revised on 30 November 1972. So the interesting thing about the grace period in Europe is that it's not 1 year, as in the US, but it's 6 months. Okay, 6 months before the party, public disclosure would not be taken into consideration, okay, for the application in regards of Article 54. But there are two main cases. There's not just any kind of public disclosure in an international exhibition and blah blah blah. But even if there is an abuse done by the applicant or by his legal predecessor. What does it mean? That the applicant abuse basically received an abuse, or his legal predecessor received an abuse that led to a public disclosure. Okay, so this one is interesting because in the US no one cares about this, basically, right? No, it's not interested. The US doesn't touch it, okay, in section 102 A and B. But here in Article 55, APC touches it. This is interesting because it's the division we spoke about before, that there is always in the European law a flavor of humanistic law, of human right, that doesn't exist in US, that instead has a much more practical approach, the one of the utilitaristic way of the incentivization interpretation of the whole thing. Let's see the important case in the European Union. So we will have T51/81, the Sirani case in 1982, in which the case underlines that the mere art of handling on a sample or making another disclosures does not automatically mean that the invention has been publicly disclosed. Okay, remember there is the enablement requirement even here in Europe. Okay, so but is not called enablement actually, but is the same thing basically. T381/87 in 1989. The court held that the sale of a machine can lead to a loss of novelty if done without a secrecy obligation. This one we have seen is in relation with the US case law. T472/92, 1993, the court held that the content of the oral disclosure must be specific as the written description. So, as we say, the written description is important for enabling the person skilled in the art to use and recreate the invention, and this one is the same thing. In T472 and /92, it is described that. In T1081/01 in 2004, the court held that the disclosure must be enabling and able to all persons skilled in the art to understand and repeat it, as we said before. Then in T1463/11, the Sandler case in 2015, the decision claiming that even if some features were not disclosed, if a person skilled in the art would be able to replicate the invention, then the disclosure happened. Okay, so the disclosure requirement is so important that actually even in the Sandler case, if not everything is described, if still I could have enough information for doing the enablement and to replicate the invention, then there is a public disclosure. Let's look to China now. So in China, we will have again Article 22. Article 22 of the CPL basically contains everything in relation to requirements in which novelty is designed, and it means that novelty means that before the filing date of the application, no identical invention or 3D model has been publicly disclosed in domestic or a foreign publication, or has been publicly used or made known to the public by any other means in the country, nor has any other person previously filed with the patent office an application describing an identical invention or 3D model that was recorded in patent application documents published after the said date of filing. Okay, so as before, we have seen the same in section 102 and article 54 in the European Union. The thing is that we don't want to see an application that contains an identical invention or an identical something similar or totally the same described as a patent application. So the prior art mentioned, right? Now, Article 24 of the CPL focus on the exclusions. Any inventions for which a patent is applied shall not lose its novelty if, within 6 months before the filing date of the application, one of the following events has occurred. It was exhibited for the first time at an international exhibition sponsored or recognized by the Chinese government. It was made public for the first time under prescribed academic office, or it was disclosed by any person without the consent of the applicant. So we see that there are 3 requirements here. That there is a public disclosure within 6 months, so similar to the European Union, 6 months even there before the filing date, that it happens, or in a sponsored convention by the Chinese government. This one is interesting, right? Because you see the role of the central role in a semi-communist country as China of the Chinese government. So the Chinese government, if a Chinese government give you the permission to actually show the invention in that particular conference, then you are covered. The second is that you are covered anyway if you don't have that permission, but it must be an academic or a technical related convention. And third, there is a reaffirmation of the European principle that there was an abuse to the inventor in order that led to the disclosure. This that any person, without the consent of the applicant, have actually performed the disclosure, right? In China, there is a requirement for absolute novelty, similar to the one in the US. Any disclosure, so much that any disclosure anywhere in the world means having performed a prior disclosure. And if outside the 6-month grace period, then it won't lead to a patent grant, basically. Now, inventiveness. This one is the last step, and inventiveness could be interpreted even as non-obviousness, if I'm not mistaken, in the US, indeed, non-obviousness. That instead, section 103, in which is described that a patent for a claimed invention may not be obtained, notwithstanding that the claimed invention is not identically disclosed as set forth in Article section 102, if the difference between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skills in the art which the claimed invention pertains. Patentability shall not be negated by the manner in which the invention was made. What does that mean? This one is the affirmation of the posita, the person with ordinary skills in the art, that is going to decide if your invention is actually obvious or not obvious. What does it mean? That if I am a person skilled in the art and I see that invention as obvious, as something that it doesn't require a great inventive steps, okay? I took your invention as novel, as seen in section 1 or 2, and so nobody I'm talking about before and so on. Still, your invention won't be granted a patent. Why? Because basically for them, you don't have the necessary skills, you don't have the necessary inventive steps that leads to a new patent granting. Important cases on this are Hodgkins and Greenwood in 1850, in which it was set a rule for non-obviousness that explained that a mere substitution of material does not entail enough ingenuity to deserve a patent. Graham versus John Deere, 1966, if you remember, it was a very important case because it actually linked patent law to the US Constitution, and it actually linked it to the necessity of the US of fostering innovation, so incentivizing steps, right? So anyway, in this case, the court held even that the non-obviousness inquiry is not based on subjective material, but on the assessment of the previous states of the art, okay? In Ray Winslow, then, always in 1966, the court explained that the case that a simple assessment of prior art is not enough, but it is necessary to assess how the prior art elements are assessed by the posita, so by the person with ordinary skills in the art. What is the difference, though, as we say, to Section 103 and Section 102? Section 103, the non-obviousness, and Section 102, the novelty. So the novelty requirement, as we say, is an internal requirement almost, okay, of the USPTO. What does it mean? That I don't want to see that there are no other applications with the same invention on it, or that there is any other public disclosure of this particular invention. Okay, so it is just related to that particular invention. Section 103 instead is related to the broad field of the technical field itself. So no, it's not only enough if your invention wasn't mentioned or wasn't disclosed before your patent filing, but even that if before your patent filing anyone that was inside the tech field wouldn't seen it as a obvious step to make, as something obvious, as something that was immediate to make. Okay, so it's much more related, as we see here, both to the posita knowledge, ordinary knowledge of the tech field, but even on the assessment of the state of the art. So you have a state of the art and of the great big tech field that need to be assessed by the court itself and by the USPTO or the patent office, but even that need to be assessed by the posita itself, and even its understanding of the person with ordinary skills in the art need to be taken into consideration. So how much, not subjectively, but objectively, a person that with ordinary skills in the art will interpret the whole case. Now let's see our flying object. Now let's see in the EU. In the EU, non-obviousness instead is defined as the inventive step, as we said before, and this is Article 56 of the APC, which say that an invention shall be considered as involving an inventive step if, having regard to the state of the art, it is not optional to a person skilled in the art. If the state of the art also includes document within the meaning of Article 54, paragraph 3, this document shall not be considered in deciding whether there has been an inventive step. So, as before, for section 103, centrality is given to the person with ordinary skills in the art. The app utilizes a problem solution approach to assess the inventive step. This method involves identifying the closest prior art, determining the tech problem to the invention addresses, and then explores if the claimed invention has a solution that would not have been obvious to the posita. This method requires the EU to utilize a could-would approach. The examiner in this way does not just ask if the skilled person could have arrived at an invention using the prior art, but rather if they would have done so for any reason, for solving any issue, for example. What does it mean? That the way in which there is the assessment in Europe is a little bit more trickier than the one that there is in the US. Why? Because in the Europe, there is not only the posita that is the center of the whole thing. So, the interpretation of the person of the invention and the prior of the prior art, and then eventually if the step will be obvious or not obvious. But there is even a problem solution approach. So they take it and say, okay, the court assess the problem that the invention need to tackle and the solution that it gives. And if that solution for a posita would be non-obvious, would be an inventive one. Secondly, there is a could-would approach. So it's not just the posita could have done this, so an hypothetical way, but a practical way. He would have done this, so that person knew already how to solve that issue in an obvious way. Okay, and that thing basically is called what is hot water. It's like reinventing the wheel basically, because it's already there for the person skilled in the art. Now let's see the important cases. So we have 5 main of them. So T2/83, 1984. The decision is fundamental in the EU patent practice because it clarified the approach, the could-would approach, and the EPO stated that it's necessary to look at the state of the art without knowledge of the claimed invention. No. So T5687 in 1989, in the case the court held that simply showing the presence of individual features in the prior art is not enough to deny an inventive step. Then T939/92, Agilian Tech Inc. versus Waiter Investment Ltd. in 1994, The case reinforces the could-would approach methodology, emphasizing that the examiner should focus on what the FOSITA would have done. In T641/00, Comvic versus Ericsson Inc. in 2002, this is a decision explains that merely handy and not a feature cannot create an inventive claim. In T214/06 in 2008, in the decision it has been underlined that even features that are non-tech could be interpreted to contribute to the technical character of an invention if they interact with its tech features to solve a technical problem, basically. We see the machine going down. And now another flying. So let's see China. In China, non-obviousness, defined here instead as inventiveness, is defined by the Article 22, paragraph 3 of the CPL, in which is written that inventiveness means that, compared with technology existing before the filing date of the application, the invention has prominent and substantive distinguishing features and represent a marked improvement, or the 3D model possesses substantial distinguishing feature and represents an improvement. These criteria are then further elaborated in the CNAPA with lines. So, our dear friend the Chinese actually have a step further, because they don't even require, they describe inventiveness not just as an innovative and non-obvious solution to a problem or a could-would approach that would be implemented, that a POSITA would not implement, but they even requires it to be distinguishing, so that to be something that have a differentiating features in the way that the problem is solved by the invention itself. So it's even raised in the claims itself. And now we arrive to the most important part. So when you want to draft a patent, the first important thing is basically the claims drafting. This one is the first step in the whole process. Now let's imagine we'll take all the subject matter, the requirements that we described before, novelty, inventive step, usefulness, and so on, and that we apply it to the truth. So we have our document and we start to draft it. Drafting a patent means inserting not only names, surnames, and blah blah blah, and description of the invention, but even claims. Claims are basically defenses that are going to delimit your intellectual property, saying, oh look, this is what my invention is, these are the technical features in the claims descripted, and what is inside is my invention. This invention could not be touched. This one is my intellectual property. These are the physical fences, we could say. And normally there are three main requirements that are recognized in all the jurisdiction, that are enablement, conciseness, and clarity. And we're gonna, of course, treat them. Now let's treat them a little bit more internationally. As we said, claims are the part in the end of the patent document. You can see here an example like what this claim is the introductory sentence, and then there's the description. And they act, as we say, as fences for the intellectual property, defining precisely what is defended and what is not. Now, before starting with all the claims, I take just 5 minutes break. You can take it as well if you like, and I return immediately. Okay, so I hope you enjoy your break. So let's return to our lovely presentation. So we see that there are three main requirements that are for the claims, that are the enablement from one side, and the other is actually the conciseness and clarity of it. So let's see the enablement requirement first. In US, this one is regulated through section 112, and in which is written letter A that in general the specifications are contain a written description of the invention and of the manner and process for making and using it.
in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains or with which it is most nearly connected to make and use the same, and shall set forth the best mode contemplated by inventor or joint inventor of carrying out the invention. In letter B instead, it's written that the specification shall conclude with one or more claims that particularly pointing out and distinct claims the subject matter which the inventor or a joint inventor regards as invention. So what does it mean? So in section 112 we know in the letter A that is written basically that the specification must enable someone skilled in the art to actually take and reproduce the invention without undue experiment, and on the second case the fact that the specification must be concise and clear enough to contain at its end the claims itself. So this one is the requirement of the enablement. So you will have two things, the enablement requirement, and the other one is the conciseness requirement that we see mentioned in 112 letter A. So the important case regarding the enablement is in Re Borkowski in 1975, in which the court described it in the case that disclosure could be sufficient for some claims but insufficient for others, so that each claim is assessed on its own. In Christiansen versus Colt Indus Operating Corp in 1987, and the decision was underlined that the explanation must be made in such a way that will not need undue experimentation, as we mentioned before. Now, one very important one is Ray Wands in 1988. This one is very important as it sets a series of requirements that are indication for determining the fitness of the claims to determining the enablement. This is quantity of the experimentation necessary, amount of direction or guidance presented, presence or absence of example, the aim of the invention, the state of the prior art, the relative skills of the potima, the predictability or the unpredictability of the art, and the breadth of the claim. So you see that even the art, the claims, and a lot of things could actually shape the enablement requirement, beside uniquely the potima. Amgen Inc. versus Chutai Parma in 1991 is a case instead that reinforces that it's not necessary to a court to review all the one's factors to find disclosure, and they are just illustrative and not literal. In CFMT Inc. versus YieldUp International Corp in 2003, in the case is mentioned that enablement is aimed at ensuring the claimed invention is described with sufficient data for potima to understand it. Other important cases then are Liebel and Flaschheim Co. versus Medran Inc. in 2004, in which the court described in the case that disclosure could be sufficient for some claims but insufficient for others. So again, each claim is assessed on its own. Strick versus Dreamwork in 2006, the decisions underlined that the claims must be broad enough in order to let them touch deeper state of the arts. In Stoller versus Clark in 2017, is mentioned instead that the specification does not need to recite textbook science, but must have an invitation for further research. Let's see instead the EU perspective in the disclosure, that is the European way of calling the enablement. So the enablement requirement. The disclosure requirement is defined in Article 83 of the APC. The European patent application shall disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. So a patent application this way does not usually need to provide experimental proof that the invention works, but must be sufficient to and complete enough to be reproduced anyway by a person skilled in the art. Important case in this sector are T292/85 in 1988, in which the case disclosed that Apple's approach to sufficiency of disclosure emphasizes that the entire scope of claim need to be achievable without undue burden. In T609/02 2004. The decision underlines that the opponents bear the burden of the proof when raising objection in relation to the sufficiency of disclosure. In T 608/07 2009, the case reinforced that it is necessary to provide enough examples in a patent application in order to achieve full disclosure through the entire scope of the claims. Okay, then let's go to China. In Chinese laws, there is again the disclosure requirement mentioned in Article 27 of the CPL, in which is written that when a patent application is filed for an invention or utility model, relevant documents shall be submitted, including a written request, a specification of an abstract thereof, and a patent claim. The written request shall state the title of the invention or utility model, the name of the inventor or designer, the name and address of the applicant, and other related matters. The specification shall describe the invention or utility model in a manner sufficiently clear and complete that a person skilled in the relevant field of technology can accurately produce it. Where necessary, drawings shall be appended. The abstract shall describe briefly the technical essential of the invention or utility model. The patent claim shall, on the basis of the specification, state the scope of the patent protection requested. So there is even an request for a patent protection, scope of the patent
Allora ho
itself.
fatto 85%, 85%, 85%, 93, 81, 81, 87, 100,
Clients
100,
drafting
100,
then.
182, 100, 83, 100.
A certain point then is important to remind during the claim drafting. It is essential to have an explanation of why they contribute to an effective solution to a technical problem. The claims should be more broad as possible. It is necessary to ask how else may the critical feature effect be achieved. Are there other ways to achieve the same result, the non-business requirement? And finally, it is necessary for them to be clear enough, both for enablement and for the subject requirement. Now, on claims network. So, the style of network claim is described deeply in 112, 112, A, B, and C. So we've seen I, B before, and now we see even the C, so at the form. So we said before in letter A, the specification shall contain written description of the invention and the manner of the process of making and using it in such full, clear, concise, and exact term as to enable any person skilled in the art to which it pertains, or with which is most nearly connected, to make and use the same, and shall set forth the best mode contemplated by the inventor or joint inventor of carrying out the invention. The one is even the best mode requirement that we're going to see very soon. Conclusion in letter B, the specification shall conclude with one or more claims, particularly pointing out and distinctly claiming the subject matter in which the inventor or a joint inventor regard as the invention. Last, the form. A claim may be written independent or in the nature of the case admits independent or multiple dependent form, and we're going to see all of this. So, in such section, two different requirements are introduced, and the definitiveness requirement and secondly the best mode requirement. So we have seen there is the enablement requirement, the definitiveness requirement, and secondly the best mode requirement. With the first is described how the patent specification must contain a brief and precise claim. In 2014, the Nautilus case introduced the concept of reasonable certainty, meaning that the requirements for the claim drafting have become stricter as clearer claims language, or at minimum detailed specification clear from ambiguities. The same decision underlined the necessity for objective anchors, meaning clear and ambiguous language that provide definite limits to claim terms. With the second instead is underlined the necessity for specification to describe not only the method for obtaining the same solution of the one thinked by the inventor, but to underline what he considers the best practice to achieve such result with his or her invention. Important case on this matter are actually O'Reilly versus Morse in 1853. The case underscores that a patent application should claim only what is specifically interested in rather than being too broad. Considered Electric Light versus McKeesport Light & Co. in 1892, in which the decision underlines that inventors cannot overreach and attempt to monopolize with broad or abstract idea. United Carbon versus Binet Smith & Co. in 1942, the case reinforces
that the claims have the first important role of giving the possibility to the public of not committing infringement. The language itself is very important. Oaklink Inc. versus Sunglass Hut International 2001, the court decision underscores the importance of the patent specification, providing context and measuring the claim terms. Subjective terms are considered as indefinitive. Festo Corps versus Shuketsu Kinzoku Kabushiki Co. in 2022. This is a landmark decision, as it strike a balance on one end, as on one end it acknowledges the importance of the public's notice function of patent claims, while on the other it recognizes the necessity of protecting the inventor against unforeseeable changes or developments that produce equivalent invention. Philips versus AWM Corp in 2005, the decision of the court declines that the claims define the scope of the patent invention, while the specification is to be considered as a dictionary containing terms and concepts. Datamize versus Plumtree Software Inc. in 2005, this case is relevant as it points out the necessity for objective anchors. Then, as we know, there is even the Nautilus case that is very important, as it introduced the objective anchors that were first mentioned in Plumtree software. Now, EU laws on the claim networks, the style and nature of the claims. The descriptor is described deeply in Article 84 APC, in which is written that the claim shall define the matter for which protection is sought, and they shall be clear and concise and be supported by the description. As could be seen in the EU, the best mode requirement does not exist. The best mode is even, as we said before, in Article 112, Section 112, letter A, it was required for the inventor to describe the best action in order to achieve the solution to the problem that need to be clarified in the patent. Important cases in this regard are T409/91, in which the UPM Kimene OY 1993. In this case underscores that novelty could be provided even by claims where individual components could be known in the prior art. In T686/91 in 1994, the decision underlines that claims must be clear and concise, especially when dealing with methods claim. In T609/02 Amgen 2004, the case reinforced that a detailed description is needed, even if a specific detail is known in the prior art. Providing specific detail to adapt that feature to solve a problem in a new way could be enough to support the inventive step. T1073/02 2006, the court decision underscores the importance of novelty based on the use and the inventive steps, and in the same it was distinguishing between product by process claims and use limited claims. As defined in 4.12 of the examination guidelines by EPU, a product by process claim is a claim defining a product in terms of a process, is to be constructed as a claim to be a product as such. The technical content of the invention lies not in the process per se, but rather in the technical properties imparted to the product by the process. While use-limited product claims allow a known compound to be protected for first medical use, where its use as a medicament was previously unknown, or for further medical use, where the compound was previously known as a medicament. Now, Chinese law on the claims nature. The style and nature of the claim is described deeply in Article 26 of the CPR, in which is written that when a patent application is filed for an invention or utility model, relevant documents shall be submitted, including invention request, specification, and an abstract thereof, and a patent claim. The invention request shall state the title of the invention or utility model, and the name of the inventor or designer, the name and address of the applicant, and the authority that matters. The specification shall describe the invention or utility model in a manner sufficiently clear and complete that a person skilled in the relevant field of technology can accurately produce it. When necessary, drawings shall be appended. The abstract shall describe briefly the technical essential of the invention or utility model. The patent claim shall, on the basis of the specification, state the scope of the patent protection requested. The article, in this case, underlines that there is a direct and unambiguous support for the claim's subject matter in the description. The claim shall clearly delineate the essential technical features that are necessary to solve the problem addressed by essential technological features that are necessary to solve the problem addressed by the invention or the utility model. So now, let's see the final part of this presentation, that is the patent process and its defense. There are three main stages on the patent granting process common to the EU, the US, and China. The examination as to form, the search, examination as to substance, and the final grant. So let's see them in detail. The examination as substance. Prior to the examination, the application is checked as this one is the examination as to form. Prior examination is the application is checked to ensure that all the requirements necessary to accord the application a filing date have been satisfied. The filing date is important since it's from such date that some actions are calculated, such as the term of the patent and where the appropriate where it's determined the priority date of any subsequent application in any other country under the terms of the Paris Convention. Examination is normally carried out as soon as an application has been accorded a filing date. The applicant is given an opportunity to correct the defects that, if not corrected, grant a rejection. The search. Depending on the examination procedure provided in the relevant law, the search will be conducted either separately from and prior to or at the same time as the examination as to substance. In other cases, the objective of the search is to determine the prior art and the specific field of application. The patent office would double-check its documentation collection to ascertain where any documents exist which describe a solution which is in the same as or similar to that described in the application. The search itself will first cover all directly relevant technical fields and then come to be extended to analogous fields, but the need for search extension must be judged by the examiner. In each individual case, taking into account the outcome of the search in the directly relevant areas of technology. The examination as to substance. The aim of this phase is to ensure the application satisfies certain conditions of patentability, in essence, if to prevent the grant of patent while the invention is excluded from patent protection by specific provision in the legislation, the subject matter, the invention is not new, does not involve an inventive step, or is not useful, industrially applicable, so novelty, inventive step, and usefulness, and the invention is not sufficiently described in a clear and complete manner in the document filed, so claim clarity and enablement. All things that we've seen before. The applicant is given the opportunity to remove any objection and raise it during the examination as to substance phase, and if he fails to do so within a specific time, the patent office will refuse to grant a patent. Not all amendments are possible if it goes beyond the original disclosure. If and when the examination process reaches a conclusion favorable to the application, then there is the granting of the patent. And this happens, of course, if all the requirements are met and so on. So let's see the US application process. As you see, there is the inventor activity, the application preparation, the draft, and then the prosecution, receive first action, response, if it's allowed, whether or not allowed, is response from office action, amendment, and possible appeal even in regards to the patent itself. Then there is even the basic step by the IPO, the search, the substantive definition, and then so on. And finally, from China, you see it has more or less the same way of interpreting it. Then, last thing last, patent process and defense. How to define a patent infringement? The infringement of a patent is connected on the rights that are granted through it. And the rights that are granted, as we say, a monopoly, although is not a correct definition, but a monopoly on the claimed invention. The patent owner has the right to license, and the patent owner has a right to remuneration in case of reproduction or importation or utilization of each invention. These are limitations of these rights and could be decided through the patent office, which modifies the application, or by authorities, like in case of disputes or in case of public order needs. What type of patent infringement exists? We have three main patent infringement. One is the literal, that is the claims have been interpreted, they are found as bound to the patented product or process as containing every element of the claims. Contributory infringement occurs when a party supplies a patented invention component knowing it will be utilized specifically for infringing the patent, and then inducement to infringe. This involves actively and knowingly inducing another in the infringement of a patent. Finally, the doctrine of equivalence is important. The doctrine of equivalence is a nuanced principle in patent law, especially in US law, that allows a patent owner to claim infringement even if the allegedly infringing product isn't identical to the patented one. This doctrine is significant because it addresses the situation where minor changes are made to a product to circumvent patent infringement, ensuring the original patent protection. In essence, the doctrine of equivalence allows for an infringement claim when a product, although not identical, function in a substantially similar way to a patented invention. The key criteria for this doctrine was established by De Graver, Tank, MFG Co. versus Lindner Prods Inc. decision, and is a triple identity stand. The product must perform the same function in the same way and achieve the same result as the original. Additionally, the Warner-Jenkins versus Hilton Davis Chemical Co. case established a all elements rule requiring that every element of the original invention must have an equivalent in the infringing invention for a claim to be valid. And here we arrive to the end of the presentation. So thanks for your time, and I'm gonna upload soon even the last part of it that is actually related to trademarks. Thanks, and have a good night.